you think should be in control of the content of your contract? Well, under English law, some contract terms can be interfered with in the sense they might be unreasonable under either the Unfair Contract Terms Act or the Consumer Rights Act 2015. So that modifies and removes certain clauses if they're unfair. Now, unfair is quite wide, but we also have discretion of the court to modify clauses which don't meet other regulations. So it could be that the interest paid on late invoices is not considered by the courts to be a substantial alternative remedy. That's under the Late Payment of Commercial Debts Interest Act. A catchy name, I think you'll agree. But we also have cases where there might be some discretion about the reasonableness of a clause. And then we might end up in some sort of gluey drafting that says, if it's not reasonable, the court can modify it to make that clause reasonable. But the general view of the courts under English law is that their job is not to interfere with the provisions that the parties have agreed. They can interpret them, they can decide whether they meet the legislation, but they don't rewrite the agreement between the parties. So this is a clause we came across recently in a contract that was effectively an associate, a joint venture type licensing agreement between two parties, a successful business person and somebody coming into the business. And the language, well, you're going to find that this clause goes on a bit, but I'll read it slowly so you can get the gist. It says as follows, and I'm going to have to read it out because I can't remember it. While the restrictions contained in this clause are considered by us and you to be reasonable in all the circumstances, it is recognised that restrictions of the kind in question may fail for technical reasons, and accordingly you agree that both of us agree that if any such restrictions are adjudged to be void as going beyond what is reasonable in all the circumstances for our protection, but would be valid if part of the wording of them was deleted or modified, then the said restriction shall apply with such modifications as may be necessary to make it valid and effective. So this clause requires the restrictions to have been adjudged to be void as going beyond what's reasonable in the circumstances. That means they've got to have a decision of a tribunal. So first of all, there has to be a serious dispute that relates to these restrictions. Then that dispute has to be not resolved by amicable means or other mediation, negotiation, that kind of thing. Then it has to end up in court proceedings or arbitration proceedings, and then you have to have a decision that says it is unreasonable. It goes beyond what is reasonable in all the circumstances. This is a vanishingly small percentage of agreements. And once you've got that judgment, then the parties have to come back and re-agree what that clause would say. Well, by this time, they have fallen out big time. They've been to court. They've got a decision. Now they've got to come together and make another agreement. In practice, this just isn't going to happen. So this sort of provision, which allows the parties to revise a contract after the event, if they get an award which says that clause doesn't work, or the sort of clause which I've seen looking at late payment provisions, which basically says the parties agree that this is a substantial alternative remedy for the basis of the Late Payment of Commercial Debts Act. Well, that's not a decision the parties are allowed to take. That decision is one for a court or tribunal. So there's all sorts of ways in which we try and kind of undermine the authority of the parties, undermine the permanence of the contract terms that they've been agreed, undermine legislation, undermine the court. It's a mishmash. It's a nonsense. Get these clauses right first time. Don't have a second, third, fourth bite of the cherry. Get it right. The majority of clauses in a contract will be enforced by the parties for the parties without the involvement of lawyers, technical experts, statutory provisions, courts, tribunals, all that kind of stuff. So your clauses need to work in your head and in the head of your client, partner, associate, supplier, whatever. Don't wait and do that shilly-shallying around if court gets involved. Get it right. And if it's not right, somebody will eventually tell you. But the job of the person who writes this is to get it as right as possible first time, not to give you a second bite of the cherry. So have a look at your contract, see whether deep in the bowels of the contract, right at the back, there are these sort of clauses which kind of do a bit of a, if it's void, then we can do this. If it's unreasonable, then we can do that. Kind of a second bite of the cherry, and try and get rid of them. Get it right first time. You might as well, if you're paying a lawyer, get it as close as possible to what you need and what the law says. That's what you pay lawyers for. Don't allow them to shilly-shally. Your contracts need to safeguard your business without annoying everyone who reads them, making them tear their hair out in the second, third, fourth bite. Nice. Play fair, be transparent, be accurate, brief and clear. That's how you make a truly lovely contract, not a totally loathsome one.